Good morning. So today we'll be continuing with our chapter Fundamental Rights, and we'll be starting with new article, that is Article 17. What is Article 17? Untouchability. What do you understand by untouchability? What is untouchability? Yes. Okay. Right. There was certain class of people that were treated untouchables. They were not. They were restricted from entrance into specific spaces. Okay, there was different drinking water tank given to one class of people. Another caste of people were given different drinking water. Okay, so there were other ways of restricting the uh, lower caste people. Okay, and this kind of treatment was known as untouchability. Gandhiji gave them a particular name, that is Harijans. Okay, people of God, Hari. Okay, so just write down what is Article 17. What does it say? Article 17, abolition of untouchability. Now write down. It abolishes untouchability. It abolishes untouchability and forbids its practice in any form. Practice in any form. The enforcement of any disability. The enforcement of any disability arising out of untouchability, arising out of untouchability shall be an offense, shall be an offense punishable in accordance with law. Punishable in accordance with law. When it comes to law, yes, untouchability is now prohibited. Although you see in a society, untouchability is still being practiced, okay, in different forms. But if law comes to know about it, he or she shall be punished. It is a punishable offense. Okay, and this could give you an imprisonment of 1 or 2 years. Also, you will not be able to fight for elections, stand for elections. Okay, these kind of punishment is given to the person who is practicing untouchability. Okay, and for this very thing, for abolition, the particular act was brought in by the parliament. You can write down the parliament enacted Untouchability Offences Act. Offences, write down in bracket. Untouchability Offences Act 1955. Offences Act, write it in bracket. Offences Act 1955. And this was later renamed as Protection of Civil Rights Act 1955. So this was later renamed as Protection of Civil Rights Act 1955. Clear? What are the penal provisions? What are the penal provisions? Imprisonment, right? Penal means punishment. First, imprisonment for 1 or 2 years. Okay. Then, any person who is convicted of untouchability is barred for standing in an election, is disqualified for election to union or state legislature. Person disqualified for election or state legislature. Okay. Clear? These are the criminal. This is a very short, okay, article, untouchability. Clear? Next article. Article 18. What is it? Abolition of titles. Now there are 4 things said. What is title? What do you understand by titles? Yes. Earlier titles like Rai Bahadur, Raj Bahadur, okay, these titles were given and they were prefixed or suffixed with the name of the person. But what used to happen, this is a kind of discriminatory practice. Okay, now you cannot use it. The change was made and it was said that these titles will be abolished, but titles that are given for recognition of merit, yeah, for educational titles, okay, then military titles, they will not be abolished. Okay, that such titles you can use like doctorate, doctor, lieutenant general, captain. Okay, these titles are allowed. Clear? Then there was another question that came up. What about titles like, recognitions like uh, your Padma Vibhushan, Padma Bhushan, Bharat Ratna? We say it, right? Bharat Ratna, so and so. It was said that this is again not unconstitutional. Okay, these awards were instituted in which year? 1954. Okay, these titles also recognize merit. Okay, why does a person get Padma Shri or Padma Bhushan award? Because they have done something, exemplary in a particular field. Okay, and to recognize that merit, these titles are given. But a condition was applied that you cannot use these titles as prefix or suffix to their names. Okay, these titles are not unconstitutional. Huh? That is different, but you cannot use it the way you use a doctorate or you use doctor. You cannot use it prefix or suffix to your name. Okay, but of course, these titles are not unconstitutional. Clear? So, first point that was said, you just write down. It prohibits the state from conferring prohibits state from conferring titles except military and academic. Okay. Then second condition, it prohibits citizen of India, prohibits citizen of India from accepting any title from any foreign state. From any foreign state. Clear? Third, a foreigner holding any office of profit, a foreigner holding any office of profit or trust under the state, or trust under the state cannot accept any title from any foreign state, foreigner of holding any office of profit cannot accept any title from any foreign state from foreign state. But condition, without the consent of the president. Without the consent of the president. Without the consent of the president. That means if president allows, then only if president allows. You'll have to go for specific permission. Normally, it is not allowed. Okay. Fourth, no citizen or foreigner holding any office of profit, and I'll explain you the difference. This is about title, okay, and this again foreigner or citizen holding any office of profit, of trust under the state, profit of trust, office of profit of trust under the state, is to accept any present emolument or office, present emolument or office from any foreign state. Any foreign state. Prohibits, okay? Prohibits. Prohibits. Difference is, in this case, it prohibits title to foreigner. Fourth clause, it prohibits the keywords present, emoluments, and office. Any present, if a foreign state is giving to you, you are prohibited from accepting that. Clear? Okay. Any present state is to accept any present emolument or office from or under any foreign state, from or under any foreign state, without consent of the president. Again, same here. Without consent, you need special permission of the president if you want to accept any emolument, office, or any present from a foreign state. Some kind of money, Okay, just for recognition. That's what emolument means. Okay, and why this is done? Yes. Right, because you just don't know why the present is being given. Maybe for some undue favor for that particular nation. And that is why it is prohibited. Clear? So these were the four conditions. So are you understanding the difference? First is very clear. Second point, from accepting titles. Here, foreigner office of profit. Okay. For third, it is title, and fourth, it is present emolument and office. Then you can write. I explained there were certain titles that were allowed, like, you can write down. In 1996, in 1996, Supreme Court held that national awards, Supreme Court held that national awards like Padma Shri, Bharat Ratna, okay, and Padma Bhushan. These were not unconstitutional. Okay, these titles were not unconstitutional, or they were given constitutional validity. These titles were given constitutional validity. And what else Supreme Court said? That they are not violative of, they are not violative of Article 18. What was the reason? Because it recognizes merit, right? Because it recognizes merit. Recognizes merit. But there was one condition applied to it. What was that condition? What was the condition? Yes, cannot be used as suffix or prefix before the names. Okay. And what kind of titles were prohibited earlier or were given? Like Rai Bahadur. You can just write the titles of nobility like Rai Bahadur, Raj Bahadur, Rai Sahib. These were prohibited. Raj Bahadur, Rai Sahib, Maharaja were prohibited. Yeah. You must have seen in movies. So in so Maharaja Padhar Rahe Hai, right? Ha, 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 ha. That is now they are there as prince, but they are not prince today. Okay, वो एक record पहले था, so they refer it in that way. Okay, but normally you will not see people using it in constitutionally. Okay, what do we say? Maharaja the, right? Next, this is Article 18. Next article is very important. Article 19. What is Article 19? Yes. Talks about 6 freedoms. First, write down 19(1)(a), right? Freedom of speech and expression. Freedom of, I'm writing it in short, freedom of speech and expression. 19(1)(a). Then 19(1)(b) is freedom to assemble peaceably without arms. Peaceably without arms, right? Third, to form association or union. To form association or union or cooperative society. What is 19(1)(d)? To move freely throughout territory of India. Freely. To move freely throughout the territory of India. Then reside and settle in any part of India. To reside and settle in any part of India. Do we have next article? Do we have this article? See what I've written. 19(1) clause F. This was right to property 19(1) clause F, which has been deleted, which is made legal right by 44th Amendment Act 1978. कौन सा legal right? Which article? Which part? Part 12. Clear? So this is the article which is deleted by 44th Constitutional Amendment Act 1978. Made legal right, Article 300A, Part 12. Clear? Now, legal right. Clear? Earlier it was a fundamental right. Remember it, it is 19(1) clause F. E के बाद we directly now have G. What is it? Right to practice any profession, okay, anywhere in the country. Huh? No, not here. 25. 23, 24 is right against exploitation. Right to free, right to profession. practice any profession. You can write right to practice any profession or to carry on any occupation. Or carry on any occupation. Clear? Now, what do you think? Are these freedoms absolute in nature or are they qualified? Yes, there are certain restrictions placed on them. Okay, like for example, remember, not absolute. Okay, there are restrictions. Next. What kind of restriction is there on freedom of speech and expression? And many a times you'll come across news articles where people are saying our freedom of speech and expression is being taken away. Yes. Things that undermine the safety and security of the nation, unity and integrity of the nation, you're not allowed to have that kind of freedom of speech and expression. Okay. At the same time, normally if you are creating chaos in the society, okay, you are restricted there. Okay. Now, this freedom of speech and expression can be of different forms. Okay. It could be in form of writing, painting, you know, anything if you want, you can document. Okay, writing, painting, printing. Okay. Yeah, why not? Okay. So that is what freedom of speech and expression is. Also, very important thing, freedom of silence. You're allowed to stay quiet as well. That is also part of freedom of speech and expression. Yes. Okay, you can write down. Even freedom of silence is part of freedom of speech and expression. Clear? Yes? No, why not? You want to sit quietly. Can I force you to speak? That is understandable. When do you understand something is good? When you have something bad existing. There are two sides of the same coin. Right? That is what freedom of silence being part of 19(1)(a), freedom of speech and expression. Second, freedom to assemble without arms. Clear? Restriction is there. See, it is clearly said, it is quite explicit in the article, without arms. Now, like if section 144 is placed, what happens? Under section 144? Yes, restricted to, yeah, not more than 4 people can gather there. Okay, that is what. So you can write down section 144 of Criminal Procedure Code. Under section 44 of Criminal Procedure Code, 144, section 144, restriction, section 144 of Criminal Procedure Code, magistrate can restrain an assembly, meeting or procession. Magistrate this is a restriction. This is the new change now. Then if I haven't gone through. With respect, you're talking about this article. I'll go through it. See, just now you just write section 144. Okay, CRPC. Whatever current update is there, you can write it. Okay. Can restrict an assembly, meeting, or procession. Third, again, it is easy to understand that there's freedom to form association, union, or cooperative society. This one is easy. Okay. Union or cooperative society. Of course, very natural to understand if you are forming any association or union, it should be for good of the country, right? So, of course, you cannot organize a group for doing illegal activities. Right? Illegal. It could be different form. Okay. Clear? Third. Then 19(1)(d), move freely. Here too there's a restriction. Okay. Restriction is that there is restriction if you're moving into a tribal area. For safety, for of tribal culture, okay, language, you can be restricted. In Andaman and Nicobar Islands, there are many tribes which are endangered. And people from mainland India or non-tribal people are not allowed in those areas. One, yes, allowed. Why? Because the language needs to be saved, the culture needs to be saved, and also, we are endangering their life. They are not exposed to different kind of diseases, which you might take with you, okay, and endanger their life. Many tribes are extinct, many languages are extinct. I guess in 2010, there a couple of languages got extinct forever because people speaking that language are dead. Okay, so tribes also, you need to save their culture, their kind of life, and for that, your freedom of movement will be restricted. That is true because again, they are very alien to you. They find you very alien. So, and they also think that you might endanger their life, just like an animal does. Okay, you might kill them or something. Okay. Also, we have seen, if you come across, you must have seen some videos wherein, people they are treating them inhumanly. Their dignity, they're asking them to dance and all. Okay. And they don't understand that thing. They're very, innocent in that. Okay. So that is why freedom of movement is restricted. Also, freedom of movement can be restricted for your health concern. A kind of restriction was placed when COVID was there, right? Yeah. Also, if there is some disease, for example, movement of maybe for prostitutes and all, some area is there, restriction is there for health concern. Okay, it could be in different way. And you have seen this freedom of movement restriction during COVID, right? So this again is any pandemic. Okay, so freedom of movement can be for safety, restrictions are there for tribes. I'm just writing the word, okay, tribal area. Then for any pandemic, epidemic. This way you can link current affairs, right? Then 19(1)(e), reside and settle. Yeah, yes. Earlier it was restricted. You cannot purchase some property or. So similar goes with tribal area. You can notice one thing that both 19(1)(d) and E are some way complementary to each other. Okay, you can write that these two articles are complementary to each other because they are overlapping. Okay, and so they are complementary to each other. Mhm. Assembly and association, some way. Okay, but here specifically without arms is stated. Then comes freedom of profession. What kind of restriction can be there? Yes. Yes. Mhm. Ah, that is there. That is one thing. Any whatever profession you want. But what is the restriction? Can you do business of drugs? No. Okay. Or any other illegal business? That is the restriction. You cannot do an illegal business. Okay. That harms the society. Okay. हाँ, ठीक है. So we are done with these 6 freedoms. Also, under this 191G, government can also put certain restriction with respect to qualification. For example, you are an engineer and you say, no, I want to be a doctor. Can you practice being a doctor until you have a degree of that? This is also a restriction, right? On like you cannot say like I want to uh, go into any profession. Only if you have certain qualification, you can practice that profession. Being a doctor, being an engineer, being an architect, being a civil engineer. Okay, if you are an artist and you say, no, I want to construct a building, will you be allowed? Then I want to do. You can say that no, my Article 19 is being taken away. What will government say? What will government say? No, this is not no way you can get that right. Okay, because certain qualifications are needed to practice certain profession. This is another restriction. Write down these restrictions. Okay, write down these restrictions. What restriction is there? First, yeah, illegal business not allowed, is prohibited. Okay. Government can state certain qualifications for a profession. Okay. Like architect, engineer, etc. Doctor. Okay. So this is all about Article 19. Clear? Any problem? Then comes Article 20. This is important. Protection in respect of conviction for offences. Article 20. Protection in respect of conviction for offences. Write down. It grants protection against it grants protection against arbitrary arbitrary and excessive punishment, arbitrary and excessive punishment, to an accused person, to an accused person whether citizen or foreigner, or legal person like a company or a corporation. Person like a company or a corporation. Legal person like a company or a corporation. Now, what kind of protection is there? There are three provisions in it, three very important terminologies, three provisions. Number one, ex post facto. No ex post facto law. I'll explain what it is. No double jeopardy. Third, I'll explain each one of them. No self-incrimination. I'm just writing the keywords. You can read it in detail. Okay, I'll explain what it is. No ex post facto law. What does ex post facto law mean? You're trying to figure out the literal meaning. Ex post facto law. Any law that can be implemented from back date. That is ex post facto. Okay, any law that can be implemented from back date. Now, what this particular article says that we cannot opt. No, there shouldn't be any ex post facto law. No ex post facto law. For example, and there's a condition here. This is possible only in criminal cases and not civil cases. I'll explain this. Only in criminal cases, not civil cases. For example, Apoorwa, okay, she stole something, 10 rupees from Tisha, Navya, okay. And today the law is that she will get imprisonment of 6 months, okay. This is current. Under this, one condition is fulfilled, that yes, she can be punished only for 6 months. If this particular law is changed after this crime is committed, maybe after 3 days, the law is that for stealing 10 rupees, she'll get life imprisonment. Which law will stand against her? Life imprisonment or 6 months? 6 months. You actually, conflicted with which particular law? The present day. Okay, for example, today is 2nd July. 2nd July, this law is punishment is 6 months. On 6th July, it was made life imprisonment. But you will get punishment for 6 months because it was this very law that you broke on 2nd July. Clear? If a person commits a crime on 7th of July, okay, if for example, same thing was done by Tisha on 7th July, what punishment will she get? Life imprisonment. Okay. Similarly, if it is said that this particular law of 6 months was changed into 7, and it is said that, okay, Apoorwa committed a crime and state wants to take a revenge against you and says, no, we will implement it from back date. It is possible? No. Remember, in criminal cases, there is no ex post facto law. You cannot implement a particular law from back date. Okay. It will only be on that very day. So, whatever law you broke, if that was valid on that day, you'll be punished only for breaking that law, not the law that is being formed in future. Clear? Now, what I said, and not civil cases, right? For example, taxation or taxation. For civil cases, for taxation, today tax is 3 rupees. You did not pay tax. Tomorrow it is made 10 rupees. How much tax will you pay? 10 only, because it is implemented from back date. So this is a very good protection for a convict. This can happen. Sometimes people want to take revenge. Okay. So this is no ex post facto law. Clear? Next comes no double jeopardy. कोई doubt है इसमें? 10 rupees. Yeah. वो ex post facto हो जाएगा. That is from back date. No ex post facto means not from back date. Criminal cases are only no ex post facto. Okay. It is an ex post facto is only in civil cases. Okay. Next comes no double jeopardy. What is no double jeopardy? Yes. A person cannot be punished for the same crime twice. There was a movie on this particular, it was a Bollywood, I don't know the new movie. This was the movie. Amitabh Bachchan was there in that movie, Andha Kanun. Okay. He was punished for a murder of particular person. Okay, he was given an imprisonment of 20 years or something. And later it was found that he was alive. He spent 20 years, came back, and he found that the person is alive for whom he was punished. What he did, he took revenge and then he murdered, in front of the court, he murdered that person. Then the court said, what did he say? You cannot punish me. You cannot punish me. You punished me earlier when I was trying to save myself, and you punished me 20 years for the murder of this person who was already alive. Now if I murder him, you cannot punish me. Why? Because you cannot punish the same person for the same offense twice. Getting? He took the benefit of that loophole. Okay, because he was already punished for the murder of that person 20 years. How can now, when he actually murdered that person, how can the court punish him now? So that was all about that movie. Okay, not exactly, there were certain differences, but this is exactly what he tried to pick, that loophole. Okay, so that was no double jeopardy. Clear? Next, no self-incrimination. No self-incrimination. You cannot, if you are committing a crime, I cannot force you to be proof against yourself, a witness against yourself. Orally, okay, no, you have to say yes that you committed until unless you want to do it willingly. That is different thing. But no force can be applied. Okay, that is what no self-incrimination. A convict cannot be a witness. An accused cannot be a witness against you. A force cannot be used to for an accused to be a witness against himself or herself. But this is not right actually. Okay, that is why we are talking about police reforms. Correct. But again, there are certain conditions. Not conditions. Certain witness, you being a witness, you have to compulsorily obey it. For example, Your blood sample, you cannot say no to it. Your blood sample is also used, in case of rape and everything, blood sample of that person is used, or hair. So that you cannot do. You can say, ma'am, that is also being a witness against yourself. No, these things are allowed. Blood samples, sign, forensic text. There, the accused must obey the law. Okay, clear? But oral witness, some documents, that is not allowed. Okay, that cannot be forced. Write down. Okay, shall I dictate it? You can just, as for no self, you can write, no person accused of a crime, no person accused of a crime can be compelled to be a witness against himself. Can be compelled to be a witness against himself. You can write in bracket oral or documentary. Oral or documentary. Compelled to be a witness against himself. In bracket oral or documentary. But there are certain exceptions to it. You can write exceptions. Specimen blood, signature, physical examination of body, etc. This must be given by the accused. Or accused cannot deny to give this. Accused cannot deny to give this. Deny, or this must be given even by accused. Blood sample, signature, examination of body. Okay. Then in case of double jeopardy, just write down not applicable in administrative or departmental case. Not applicable in administrative or departmental case. It is applicable only in court of law or judicial tribunal. It is applicable only in court of law. It is applicable only in court of law or judicial tribunal. It is applicable only in court of law or judicial tribunal. Double jeopardy clear था, ex post facto clear. Next, done. If anyone asks you what is protection in respect of conviction of offences, you'll explain these three things. You're done. Okay. No double jeopardy. Remember movie Andhaga. Okay, याद हो जाएगा. Next, very important article. Article 21. What is it? Protection of life and liberty. What's the liberty? And in case ever you get a chance to watch that particular scene, for lifetime you'll memorize it. No double jeopardy, Amitabh Bachchan and the cartoon. Okay. For protection of life and personal liberty, this is very important article. You can write down. No person shall be deprived of his life. No person shall be deprived of his life or personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Except according to procedures established by law. I'll explain what this means. The term except according to procedure established by law. Okay. For that, we need to understand two cases. Okay. First of all, what does it mean? Can you repeat the sentence? That is, through executive action, you can be deprived of your life. Means death. Okay. But not except procedure established by law. That means this particular law does not apply on legislative action. Okay. If a law says that this person needs to be deprived of his life, written, law is saying it, legislature is saying it, parliament is taking a decision, state legislature is taking a decision while making a law, that is allowed. Okay. But executive action is not allowed. That is what it says. That no person shall be deprived of his life. I'll make it more clear. ठीक है, थोड़ा बहुत समझ में आ रहा है अभी? I'll explain. I'll explain it. This right says protection of life and personal liberty. Actually, it has been reformed through two cases. Okay, now we have due process of law. Earlier, it was procedure established by law. Okay. What it is, I'll explain the difference. First write down the case. A.K. Gopalan versus State of Madras. A.K. Gopalan versus State of Madras, 1950. I'll explain you. Okay, what you're talking about, we'll see that in other articles also. But here, this is different. Okay, what it is, I'll tell you. A.K. Gopalan versus State of Madras, 1950. This article takes a narrow, remember this, it takes a narrow interpretation of Article 21. I'll explain why it is narrow interpretation. Narrow interpretation of Article 21. Write down. इसको लिख लो. ये लिखना है A.K. Gopalan versus State of Madras. Write down. It held that protection under Article 21 is available only against only against arbitrary executive action and not from arbitrary legislative action. And not arbitrary legislative action. Protection available only on arbitrary executive action. I explain. And not arbitrary legislative action. That means, why narrow means which is very small, not wide interpretation. ठीक है कैसे? हाँ, it is narrow interpretation, narrow, very narrow view of Article 20. When how it is narrow, I'll explain. First is this. First reason for narrow interpretation is that this protection is available only on arbitrary executive action and not legislative action. Executive means action being taken by the government, by the president, okay, by the governor. Okay. If such an action is arbitrary matlab which doesn't have any reason, which does not go with your right set, it does not involve right set of rules and regulations, okay, which is unethical, okay, this particular right will grant you that safety against executive action, okay. If president says this person needs to be given death penalty and it is found, okay, that this action of the president is arbitrary in nature, this is wrong, unethical, okay, then you can claim your right under Article 21. But this particular case stated that this article is not applicable when it is arbitrary legislative action. That is, if in form of law, if Parliament makes a rule which you find is unreasonable, unethical, you cannot claim your right under Article 21. Clear? If it makes a law and you find that that particular law is unreasonable, it is giving you death, and you know that this whatever law is made by the Parliament is unreasonable, is not fair, is unethical, okay, then you cannot claim your right under Article 21. Clear? I'll tell you. It has been reformed now. Okay, now you can claim your right against both arbitrary and executive action, both arbitrary executive action as well as arbitrary legislative action. And this was held in Menka Gandhi case. Clear? So, narrow interpretation, are you getting what I meant by narrow here? When I make you write and understand second case, you will understand why this is narrow and why that is wide. Okay. Second reason for it being narrow was that it said that Article 21, just write down, second reason, SC held personal liberty, SC Supreme Court held that personal liberty means only liberty. Supreme Court held personal liberty means only liberty related to the person or body of individual, related to the person or body of individual. What does this mean? I see Tisha sitting here. I give you the freedom, absolute freedom to stand here, sit here. Okay, but I say that you're not allowed to drink water. You're allowed to eat food. Okay, I restrict your freedoms in other ways. Only your physical presence is being bothered, is being taken care of, but not other things. Or you are being tortured in other ways. Okay, that is what A.K. Gopalan case said, that liberty is only body-wise, only person, body-wise. That is the only thing that you can claim under Article 21. Clear? Only physical. Clear? That is why this was narrow. Okay? So liberty only body. ठीक है? Is it clear? This is narrow interpretation. Now let's come down to Menka Gandhi case. First वाला clear हो गया है. Shall I make you write further line in this? Will you be able to explain this? Protection available only on arbitrary executive action. Okay. Try reading Lakshmikant. You'll understand them in little more detail. Okay. Write down Menka Gandhi case versus Menka Gandhi versus Union of India. Menka Gandhi versus Union of India, 1978. When it comes to Article 21, you must remember these two cases. Very, very important. Okay. You will not be able to explain this article without these two cases. Now, this took A.K. Gopalan case, narrow interpretation. This broader or wide, broader interpretation. Now, what broader interpretation was taken? Number one, very clear. Protection available for both arbitrary executive action and arbitrary legislative action. Protection available for both arbitrary legislative action and executive action. ठीक है. Second, this is important. You can write down personal liberty not limited to mere animal existence. Personal liberty not limited to mere animal existence. It is quite holistic. You will understand. It means, it says that if there's an individual and if this individual is free, then there are other things automatically that this individual will get, like dignity. Okay, then privacy, shelter, clean environment, right to information, free legal aid, right to sleep. This is also part of liberty. Right to sleep. And there are many more rights. Clear? बहुत सारे rights हैं. Okay. So, an individual is not just physical presence, right? There are other things that automatically come with that individual. So, this was the broader interpretation that came under Menka Gandhi case versus Union of India. This is what protection of life and personal liberty means. Clear? समझ में आ गया? So that is where right to privacy is also part of this. Yes. Right now we have this holistic. When you talk about individual liberty, you must get all these rights. ठीक है? Clean environment, clean breathing air. आपको एक toxic जगह पे रख दिया जाए. Are you free? So whenever we talk about clean environment, you talk about right to life and liberty, because that is part of liberty. ओके, क्लीन एनवायरनमेंट नहीं रहता तो जिंदा रह के क्या करोगे, राइट? ब्रीदिंग प्रॉब्लम है, ठीक है, you will be spending most of your time in hospital and with oxygen cylinders. That is not quality life. Quality life is something different. ठीक है, that is what right to love life and liberty is. What's the time? Okay. I think we'll not be able to start Article 21A. Shall I start? Okay, we'll discuss a bit. Article 21A. What is Article 21A? Right to education. This article states that state shall provide, state shall provide, keep writing, okay, whatever I write here, please write it in your copies. Also, whatever I dictate, because while revision, it will be easy for you. Okay, state shall provide free and compulsory education. State shall provide free and compulsory education to all children, of age 6 to 14 years, of 6 to 14 years. 14 years. This was inserted by, next point, inserted by 86th Constitutional Amendment Act 2002. Yes, yes. Yes. Inserted by, this is very important, okay? That which particular amendment act, this could be an MCQ, which particular amendment act inserted Article 21A. It is not from very beginning, okay? It is in 2002, this right was given to you by 86 Constitutional Amendment Act. Yes. And now this particular amendment made certain more changes. In Article 45 also, which is a DPSP, it made change in the language. Okay. And remember, right to education, this needs to be clarified that this is only for elementary education. Free education, but only 6 to 14 years. Okay. Not for professional education, not for higher education. Else you can claim, ma'am, government should give fee for us also, because no, we'll say no, your Article 21A is not being given to us. You're not 14 years of age. Okay, it is not applicable for professional or higher education. It is only applicable for elementary education. You can write, this right is not applicable for higher education or professional education. It is applicable only for elementary education. And this could be a question, like you said, that whether this kind of right was there with you or not. Yes, it was there, but it was a DPSP. You can write. Earlier also education for children was there. Earlier also, write it down as note. Okay, note. Earlier also education for children was there under Article 45 in Part 4. Under Article 45 in Part 4. But this was a DPSP and not a fundamental right. 45 in Part 4. Yes. A DPSP, that is Directive Principle of State Policy, and not fundamental right. Now write down certain points related to 86 Constitutional Amendment Act. Now this could be an MCQ. What changes were brought by 86 Constitutional Amendment Act 2002? Point wise. First, it changed subject matter of Article 45. It changed subject matter of Article 45. You can write written. Article 45 now reads. Article 45 now reads. Now reads dash. State shall endeavor to provide endeavor to provide early childhood care and education. State shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Until they complete the age of 6 years. Clear? You can understand now why the language was changed. Under DPSP, you will be taken from 0 to 6 years. Under right to education, from 6 to 14. So, in a way, government is taking care of you from the day you're born to 14 years of age. One part through fundamental rights and early part through DPSP. Also, one more change this particular Amendment Act made. It added new fundamental duty. This is also important. It added new fundamental duty. See, if you're writing point-wise, it will be easy for you to memorize. Right? It added new fundamental duty. Article 51A, there is one part in Article 51A. What it reads, it shall be duty of every citizen of India. It shall be duty of every citizen of India to provide opportunities for, it shall be duty of every citizen of India to provide opportunities for education to his child. To provide opportunities for education to his child or ward, W-A-R-D, ward, between the age of 6 and 14 years of age. That means your guardian, your parents also have equal duty to take care of your education from 6 to 14 years of age. Although it is of course understandable from very beginning. Okay. And it was under this particular article only government brought very important act, Right to Education Act, RTE Act 2005. You can write, in pursuance of Article 21A, Parliament enacted, pursuance of Article 21A, Education Act. Parliament enacted right of children to free and compulsory education. Right of children to RTE Act. That is, full form is Right of Children to Free and Compulsory Education. Act 2009. 2000. Full form of RTE is Right to Children to Free and Compulsory Education. RTE Act 2009. Right of Children. Clear? So this is all with Article 21A. Tomorrow we'll start with Article 22. Clear? If I ask you to explain each and every article, will you be able to explain? Will you be able to write an answer? Yes. 17, 18, 19, 20, 21, in detail, and 20. Okay? Okay, that's all for the day. Thank you.